You don't, I think even the most hard-nosed free speech person stops at people dying. You can't counsel murder, and so that's very problematic, the release of those names. I'm not sure I'm completely with Lorraine in the sense that, she just seems to say that if something, there's good national security effects from lots of open transmission of information. The guy, Manning, was a private. I mean, what kind of a system allows an American private to download all this information? I mean, maybe the Americans actually do need a little bit more controls. I know after 9/11 they moved to open, but there's open and then there's letting some private walk into a room and download every sort of informant you've got on the books, and it seems to me that's ridiculous. So, I mean, we need the pendulum to swing back a bit, and if nothing else, I assume that, I mean, if Manning can do this for a song, then who knows what kind of stuff's been released to the Chinese or the Russians. It seems like they've gone complete, it's beyond belief when you read this how easy it was to get it. So I'm not sure I agree that it's a real tragedy in the long run that, the Americans might tighten up a bit and, some two-bit little private can no longer walk into a room and download every important information they have. But other than that, I'm largely in Lorraine's camp, I think.
Lorraine, did you have any?
Well, I think I'm in your camp on that, because I certainly don't think it's a good idea that you can have some private walk in and download a heap of information. I just think from a freedom of speech perspective, I think there's a big difference between what Bradley Manning did, which I don't think is a matter of freedom of speech, versus what WikiLeaks has done, where I think there are freedom of speech issues in terms of allowing news organisations to publish leaked material. In the case of WikiLeaks, I don't think they've exercised nearly enough discretion or responsibility in terms of their provision of that material, and that's the point that I think really was trying to be made in the paper.
I think we all agree that Channel 10 Special will be fair, unbalanced, and perfectly neutral on every aspect of the thing.
Can I add a point? Because I was also thinking when you were, my wheels were turning, talking about national security, there were actually two very core cases as far as national security is concerned and free speech. One is the Pentagon Papers case, which of course in the Anglo-Saxon world is very well known. And another one that was quite similar that was decided by the German Constitutional Court, and it's called the Spiegel case. Spiegel is the leading big news magazine in Germany. And they had published in the 60s, in 1962, a title story that said limited readiness. And it went to the state of the West German armed forces, their height of the Cold War, Cuba crisis, everything, the tensions boiling. And they published, based on highly secret documents that had been leaked, an assessment of the capabilities of the West German military, which was not good. And of course, there was, Cold War, national security, treason, all of these things. Pentagon Papers similarly, and there you can create the problem with the WikiLeaks is it's easier to say to WikiLeaks, yes, that is irresponsible, and to put the names forward and to create that type of damage, but you can theoretically create, and that is of course all those who believe in state secrets would say, you can create similar, if not worse, damage by publishing these types of Pentagon Papers or whatever it is, and to find the balance between we need to have that debate, and therefore we need to have the information, and responsibility is really a fine line.
Okay. Yes.
The discussion about Assange is proceeding on conflict between citizens' right to know and state interest and security. There is another lens through which this issue arises, and that is property rights that people have in information. So, for example, if your doctor was to go out and publish your medical records, she would be breaching a very serious rule. There would, in fact, be criminal consequences for it, but there would also be civil consequences. Equity obviously directs itself to confidence first amongst other things. This was attempted to be resolved in the Spycatcher case when Wright sought to publish his biography in Australia. Is there a tension between private interests in information, property rights if you like, and freedom of speech, or is it an illusion? And if there is a conflict, how is that best resolved?
Well, I would say absolutely. I mean, if you look at the documents that WikiLeaks are now releasing, it's the spy files, which is a tranche of security and intelligence information taken from a private company in America that actually makes its money by selling that information to other people. So certainly there are clear private interests that have been affected in or over and above the national security interests that are also there.
And the state presumably also has property interests as well. It has agency obligations, it has Official Secrets Act, but also has contractual relations with its agents who covenant not to release secrets.
Yeah.
I don't know if any of the other speakers have used that.
If I can add to it, it really is the same principal question, only in the different guise. Whether you, if it comes to a court dispute over that, whether you say, well, there's some kind of state interest in national security that prevents the publication, or whether you're going to say we are extending our private law regime to the ownership of such information, and then say, well, because it wasn't yours, it belonged to the state or it belonged to a private person, and therefore you can't publish it, comes out to the same question. Do you have, should there be a right for you to be able to publish that, or to read that, or to have access to it, or not? And it's only a different line of argument.
I suppose it doesn't fall foul of Professor James's Alice Millsian point, which is about the exchange of arguments, because arguments don't have this quality of ownership, whereas information does.
I took your first question to be rhetorical. You already knew the answer. And so on the property rights thing, well, obviously, intellectual property limits stuff without payment. And I used to be, well, I still think that we overprotect on IP, and we need some IP. I think we overprotect, although I've moderated a bit since I've started getting checks in the mail for stuff I was going to write anyway. And I keep getting this money, and I'm thinking, wow, this is amazing. But it really does, it's indefensible, but attractive. You know what I mean?
Yes.
You use the phrase the level of acceptance of the level of acceptance of the general principles laid out in the European Convention, and translating that into the domestic sphere, that the level of acceptance of legislation, for example, the racial vilification or the religious vilification legislation in Victoria. I'm reminded of a comment that Mark Stein made at a seminar here in Perth a few months ago. He spoke, and he was actually speaking in the immediate aftermath of the release of the Finkelstein report, and he was speculating on what would be the effect of the controls that Finkelstein was recommending on people like Andrew Bolt, for example, who just recently been prosecuted under I think it was the racial vilification legislation in Victoria. And Mark Stein made the very obvious point, well, you know, if 10,000 Victorians all wrote into Andrew Bolt's blog and said, yes, Andrew, we agree with you, the state would be powerless to prosecute 10,000 individuals. So the level of acceptance that Professor Brummer was talking about, that, I mean, it may sound heretical within a room of lawyers, but isn't really the remedy. It's a self-help, it's a citizen self-help remedy, civil disobedience. If we all sign up to Andrew Bolt's opinions, the state is powerless really to enforce its will.
Professor Allen.
Well, I just say two things. Firstly, Jurgen, when he mentioned David Cameron going apoplectic about the prisoner voting, what he didn't say was that the top British judges have gone apoplectic about the European Convention too. When you get someone like Lord Hoffman letting rip about how the European courts have no grasp of common law and they're completely out to lunch, and Jonathan Sumption doing the same thing, it's not just the British politicians. There's a sense in Britain that the entire European Convention is just hammering the common law because these civilians have no clue at all about how it works. Now, I never agree with.
And they don't.
I never agree with Lord Hoffman, but on this one, he had something to say on the Bolt case. Look, I think the legislation is appalling, but the judge, Bromberg, was it Bromberg? Where is Chris? Bromberg. It's a terrible judgment. Okay, so look, everyone says, oh, they could have gone after him for defamation. Bromberg takes Section 18D, the defense, and he says you have to view it through the eyes of a reasonable member of the victim community. So in other words, you put yourself in the shoes of someone who wants to be a victim, and you say, what would a reasonable victim feel? Now look, in defamation law, it's the reasonable person. And on the reasonable person test, which would have been used in defamation, Bolt would have won. I don't, you can understand why they didn't appeal. The insurers of the newspaper, they put out about $1 million, Bolt told me. So they're at about $1 million. And what did it actually cost the insurers? Nothing. They have to put an apology up. It didn't cost them any money. So if you're an insurer, why would you pay to run an appeal that's going to cost you another $150,000, $200,000, $400,000? Why are you going to appeal when the cost is, well, Bolt's article gets taken down and they have to run this sort of pseudo-pathetic apology that nobody really believes. It's like Orwellian. So there's no way they were ever going to appeal. So the Bolt case is problematic because it was a bad judgment, I think. The legislation's terrible too, but the judgment made it worse. And I don't actually agree with you. I don't know that if 1,000 people wrote in, the government would just pick who they're going to prosecute, I think. But anyway.
Can I just just raise an issue? Like, I think, for instance, if you think about the vilification law, the religious vilification law, I think what happened with that Andrew Bolt is, so basically he was charged of racial discrimination or something of this sort, but not derived from the vilification law in Victoria. It's from a federal act. But I believe that we are facing a problem, and Professor Bremer was talking about this idea of how we draft a Bill of Rights. I mean, we have this problem with group rights versus individual rights. I mean, I think what some people now claim to be rights, I think they can be quite controversial in a certain sense, because it's this idea that you should protect the group rather than the individual. And sometimes you have the individual being, the rights of the individual in this situation being actually removed from the individual. I think I'll give an example, like I could think about, I'm not going to give examples, but perhaps I could say that there are instances of the use of Bill of Rights that have been quite bad in terms of removing individual rights. I can think about, for instance, the Dred Scott case in America that was an instance of judicial activism based on the American Bill of Rights. I actually think that sometimes you can actually use Bill of Rights to undermine the basic rights of the individual. I think it's very dangerous when you draft this kind of document that you make clear that the rights of the individual are going to be preserved, especially in this culture of entitlements, and that the groups, they feel that they should have more rights than others. And every time you give rights to a group, there's quite a possibility that the rights of the others who are not members of this group are going to be affected and removed. Because, of course, every time you empower someone, you disempower others. I mean, so you have to be very careful about this kind of approach. And another thing is the methods of interpretation available. Like, even if you draft a very good Bill of Rights, I feel that this is still a bit dangerous in terms of the approaches that the courts can take. For instance, they can apply a living instrument document in which actually they can discover new rights and they can undermine the other existing ones. I think so. Even if you draft these, you have to be careful because the judge can actually distort the original meaning of the document. So all these kind of things, they actually have to be taken into account. I believe that everybody, Professor Bremer and Alan, and everybody here agrees with the necessity of protecting the basic rights of the individual. But I actually think that's a matter of how you do that really makes us a bit different in terms of our understanding. But I still believe that the creation of some new rights, they might actually be just special privilege that can be granted to people on the basis of, for instance, race or gender and things of this nature that can actually be quite dangerous if you think about liberal democracy and every person counting as a normal individual citizen. I came from Brazil. I wouldn't be happy with the government imposing upon myself my Brazilianness, but I just want to be a normal citizen endowed with the rights that I don't think are actually given by the state. I am an old-fashioned guy. I believe that the rights are not given by the states. They are inalienable to the individual, and the states have only to recognize them. And among these rights, I still think the rights to life, liberty, and property are the most important. And they are not state-given. The states can only protect.
Free speech, too.
And free speech is a result of them, the liberty of the individual to be free to speak whatever they want. provided that's not such a thing that will disrupt certain elementary things related to national security, things like that. But everybody would agree with the idea that there are some limits to freedom of speech. I think the problem is that to whom you should give this final authority in terms of whether this is coming from the courts or if it could be coming from the legislature. I think checks and balances is actually a very important thing too. So in a certain sense, I think that these things can actually be balanced because it's not a kind of democracy that you have that you can do whatever you wish. Like there are some limits in terms of the protection of rights and things of so forth. So I have these things have to be balanced.
My point was simply that if a law doesn't have wide acceptance, 30, 40 years ago, citizens just had to take it on the chin. Now, with the miracle of the internet, they can directly defy that law, or directly express their opposition to that.
So over 50% of people are against the carbon tax. What are they doing about that? The citizens, uprising. There's no way that can be right. There's a whole bunch of things you cannot do. You have to work through the process of legislation. You got 50% of Australians just refuse to pay their carbon tax, higher electricity bill.
Well,
Come on. It can't be right. It can't be right.
Okay, we have a question down the end.
I've got a question for the Professional Senator, and I particularly ask it if someone who comes generally from civil law tradition rather than common law. At common law tradition, you can do anything you like, say anything you like, do anything you like, so long as the common law equity or statutes are otherwise. It doesn't say otherwise. And I would ask it in the context of your concern about racial vilification and truth. In common law, truth is a complete defence. How do you feel about statutory inroads which say that there's got to be a public interest or something like that? Because the statutes might say that you can't say that the politician's been cheating on his wife unless there's a public interest in it. You, it's true. So what's your attitude to truth and restrictions on information?
Well, I think that the civil law tradition was based on this understanding of positive law and codification of law. But that came mainly through the Napoleonic era, in which Napoleon decided to create the civil codes and things of this nature. Originally, the idea was actually to be based on natural law theory, but they thought that because natural law is something that's immutable, it was just a matter of sorting out the truth, and then the truth to be revealed in these codes. So I actually don't believe that the civil law tradition is based on this disregard for the truth. I think it's actually that the legislator would be able to sort out the truth, and this would be so immutable and eternal that they can actually create these codes. And the codification of law was based originally on the idea of natural law and natural rights. But of course, the result of that is that if you have everything codified, then you don't need to discuss natural law theory any longer because everything you find in the codes. So ultimately, it led to the advent of legal positivism in the 19th century, because then once you have all these codes, the philosophical discussion ceases to prevail, and then the judges have to do what Montesquieu, here people say Montesquieu, said about this idea that the judges are the mouth of the law, and they basically repeat like parrots what the law says, and they would not have to entertain themselves with relation to things such as reason and so forth, because the law would just dictate what they have to do. In the common law system, I also believe that it's also equally based on natural law theory and the discovery of the truth, but this would be done more gradually and perhaps more modestly. So according to the common law tradition, I think the idea of truth is actually very present, because I believe that both had these ideas that we have certain things that are objectively right and certain things that are objectively wrong. What this kind of legislation that we have now, the verification law, creates is like the idea that there is no objective truth. So everything is actually relative. That's why you cannot have a robust discussion, because this can actually be disruptive. So the government now is telling us that, look, these discussions about religion, first of all, religious people, they might be very stupid just to believe in God and all these things. So it's better not to have them discussing this kind of issues, because they're disturbing the peace, they're disturbing the order. That comes from a postmodern perspective that truth is relative. But it can be hijacked by absolutists like radical religionists who can actually say that, well, I know what the truth is, and if everybody defies my understanding of the truth, then I can use the law as an instrument of persecution. So I believe that it is kind of an unholy alliance between the postmodernists and the religious extremists who can actually use the legislation to persecute people who think different.
What about my question on, you were concerned about not being able to rely upon truth in religious deliberations. But what about detracting from the common law in terms of your entitlement to a newspaper can't rely upon truth in defence to a defamation?
That's why I believe it's invalid in terms of the constitutionality of this. Not that I believe that we should be so concerned about constitutional matters, because you raised the issue of the common law tradition, and I think this is actually even more important in my opinion. But it's about this idea that in a democratic debate, like normally you would expect that people are seeking the truth. And
you have to be a bit skeptical too, right? I'm largely on your side, but let's face it, when you say truth is a defense, you have to prove it in court, right?
Yeah.
So there's a big difference in life between something being true and you being able to walk into court and prove it, as every lawyer in the room knows. So often truth is not a defense. It's true. You have to prove it, and sometimes in defamation you can't prove it.
Yeah, but we start. James, just one point. You start with the assumption of your innocence. So one thing that's important about this legislation, James.
No, he's talking defamation.
Yeah,
and defamation.
Yeah. But the honest.
I'm the one being sued. I have to prove truth.
Exactly. But the point with this kind of thing is that you're being accused here, and of for instance, offending people, and then you start guilty. You have to prove your innocence. Then the onus of the proof has been inverted.
I know, you're preaching to the converted here.
Yeah, so it's
it's my favorite kind of preaching too, but still.
Okay, let me just stop you there, because we have a question over here and we need to break shortly.
Michelle, a question principally to Lorraine at this point. Lorraine, are you aware that the United States authorities have built, and must probably now have operating, a secure facility with supercomputers that will monitor every electronic communication in the world? So you will have, must probably have Big Brother now watching over every conversation we have. So this would tend, in my mind, to be counter to the concept of freedom of speech, because it's not the speech that necessarily we would want disclosed to prying ears. Doesn't worry me. I'm not going to say anything on the phone. I wouldn't care anybody else to hear. But there could be other parties that would not want this to occur. So how does that slot into the concept of freedom of speech?
I think it demonstrates the complexities of the concept. You know, as I think every speaker's alluded to, everyone in this room would say at the abstract level, we all believe in freedom of speech. It's a great thing, we should protect it, it's a wonderful individual human right. But all rights need to be weighed up against other rights. And so in freedom of speech, national security concerns are one factor that comes into play, but privacy considerations are another. And the issue that you've raised concerns me on two aspects. Number one, I'm concerned about governments overreaching and having access to that type of information in the first place. But secondly, I'm terrified that somebody might come in and steal that information and put it up on something like WikiLeaks, because as benign as my personal conversations might be, I don't want my husband to be able to read on WikiLeaks the fact that I disclosed to my sister the real price of the dress I bought last week, because as much as that might not have national security implications, it has very important marital ones. So
you haven't trained him very well.
Well, you know, I mean, a lot of the times, you know, the information that we're talking about can be very, very benign, but the fact is, it's my decision whether the conversation's private or released in public. It shouldn't be anybody else's. So I think there are some real issues in relation to the internet and how that operates.
We were facing the same problem at this present moment during the American presidential elections, because I was in America now. They have an ad by the Democratic Party basically recording a private conversation of one of the candidates, Mitt Romney. And I find it quite disturbing, actually, because...
Not really a private candidate at a fundraising.
Yeah, but he was not supposed to be recorded, so he was having a chat with his supporters. And I contend that actually what he says is not so serious, in my opinion, but could be. But I have probably said much worse things in privacy than what he said. So I think this is actually very dangerous when you have actually a person who is in this fundraising. It doesn't really matter, but he's not expected to be recorded. And then these things is placed on an ad to show how evil he is. I think this is actually unethical. I believe it's unethical, and what disturbs me is that some people don't see this as a problem, like to be recording conversations of people and then displaying this on television, when I think it's a quite problematic thing.
Can I just have a quick skeptical word to the gentleman here? Look, I work in an Australian university. Anybody who thinks that a bureaucracy is going to be a super sort of uber conspiracy that's going to monitor every word that anyone ever speaks has never worked in an Australian university where the bureaucracy is so unbelievably incompetent they can't do anything right. So the idea that there's going to be this world government super body that's going to know, it's just beyond belief. You know, the Americans, they didn't even predict the wall coming down. You know, there's no chance at all of this super conspiracy, you know, knowing every word everyone says. They can't even, you know, it takes them 10 years to find a guy living in a cave. I'm very skeptical.
Now, on that note, believe it or not, we have been having this discussion for nearly half an hour, so it does seem like it's 5 minutes, so I'm not robbing you of time, but we do need to have a break and have a cup of tea and coffee to revive and replenish.